In debate at the CHR, experts warn of unconstitutionality of Parallel PEC. The plenary may conclude on Tuesday, 12, the vote of the Parallel Social Security PEC 133/2019, but for experts who participated in this second, 11 public hearing of the Human Rights Commission (HRC), the proposal still presents unconstitutional provisions. The debate was led by the President of the Board, Senator Paulo Paim, PTRS. The Parallel PEC changes points of the Social Security Reform, PEC 6/2019, which was approved by the Senate in October and will be promulgated in a solemn congressional session scheduled for Tuesday. Among the changes proposed by PEC 133/2019 is the inclusion of states and municipalities in the new retirement system. They may fully adopt the same rules applicable to their own Social Security scheme for civil servants of the Union by ordinary law. For the lawyer and coordinator of the Brazilian Institute of Social Security Law in the Northeast, Rafaela Cosme, PEC Paralela brings provisions that can be considered unconstitutional, such as the breach of Article 150 of the Constitution, which prohibits a contribution that reaches 50% of private property. In its assessment, foreseeing a rate of up to 22%, already established by PEC 6/2019, added to the income tax contribution of 27.5%, the seizure is characterized. And when we talk about private property, we are talking about the subsistence of families. So if today we see a tax that already weighs in the server's pocket, and if we already live with misery, inequality, lack of money in the economy, we will have it even more aggravated by everything that will hit the servers. Brazilian publics, he said. José Avelino da Silva Neto, Vice President of Parliamentary Affairs of the National Association of Tax Revenue Auditors, expressed concern about the inclusion of state and municipal officials in the new rules by voting on complementary laws or ordinary laws in legislative assemblies. He considers next year's electoral dispute and the particularity of each category, such as state military pensions, as obstacles to the adoption of the new system. Security area such as correctional officers, criminal experts and intelligence officers will have different criteria from others and will cause much controversy. As well as the pension and retirement of the state military, in the case of firefighters and military themselves, said. According to Senate legislative consultant Luis Alberto dos Santos, in addition to characterizing confiscation, the Parallel PEC of Social Security as a false palliative measure to the approval of PEC 6/2019. In her assessment, she does not solve problems such as those related to isonomy, the differentiation of women in the labor market, the issue of special pensions. He said the new rules do not remove restrictions on vested rights in the case of benefits already granted, and allow the extinction of own regimes. Parallel PEC is a mere palliative measure and does not solve the problems of PEC 6. The punctual adjustments it makes are noticeably insufficient to ensure, at the very least, the right expectations. And balanced rights are what are paid to those who contribute throughout their careers. It also generates conflicts of application, given the immediate and concrete effects of PEC 6. We will have, from tomorrow, effects for people who have acquired rights whose rules will be changed when, eventually, this PEC 133/2019 is approved and promulgated, noted. Litigation Diego Montero Chiruli, a lawyer and professor specializing in Social Security law, also drew attention to what he called legal risks that PEC 133 can bring. He defined the suggestion of amendment to the Constitution as Balela PEC because, according to him, it does not represent advances and still hurts stone clauses of the Constitution. He cited as an example the creation of the Litigation Prevention Incident. The measure provides for a mechanism to allow the standardization of case law. How will I prevent the right to be discussed? If I preclude the right to be discussed in the judiciary, where will it be? Questioned. In the same vein, federal judge Fabio de Souza acknowledged that, despite the need to rationalize the system of appeals, the creation of an institute that aims to standardize the interpretation of law within the courts may cease the role of the judiciary in seeking a solution of conflicts. If the case goes straight to one of these houses, Supreme Court or Superior Court, we risk the government's arguments being received much more strongly than the arguments of the insured, or the citizens. Because it is not restricted to Social Security debates. But talk about any demand under public law, assessed. by Disability Retirement Senator Paulo Paim, despite considering PEC Paralela a measure that aggravates the situation of the insured, informed the audience participants that seeks, in the discussion of the proposal in plenary, the approval of a highlight to ensure the full retirement of disability. According to him, the pension reform provides only 60% of the benefit, which for him, is a lowered average. The citizen cannot program a stroke, a heart attack, a cancer. He cannot program. It became invalid. And? Calculate how many people are in the hospital right now. The wife next door says, look, if you don't recover, unfortunately, from tomorrow, we may have to live instead of being $3,000, being $1. $6,000. Instead of $2,000, be $1,100, warned.